G'day everyone, and welcome to week 7 of Laws 3006 Administrative Law. This week we're going to look at all of the grounds for review that we haven't covered so far. Hopefully you'll remember that these grounds for review are set out in section 5 of the ADJR Act. In week 5 of the course, we looked at the fundamental ground for review, which is a failure to provide procedural fairness or natural justice. Last week, we looked at 4 more grounds for review, the grounds which generally make up the idea of jurisdictional error of law. Those grounds for review all really looked at whether the decision maker was actually able to make the decision at all. This week, we're moving on to the rest of the grounds for review. So we're assuming that the decision-making power exists under the enactment, we're assuming that the right person is making the decision, and we're assuming that any preconditions, whether procedural or otherwise, and any preconditions for making the decision have been met. The rules that we'll be looking at this week consider whether the decision maker is making their decisions properly. Now, 2 warnings before we get started. First, I'm not going to be following the list in the ADJR Act. Instead, I'm going to group the different grounds for review together into little categories that make sense to me, because the list in the legislation really isn't in any helpful order. Second, this week has no less than 5 videos. Now that sounds like heaps, but there's a lot of material and I want to break it into bite-sized chunks. I promise it'll be worth it. In this first video, we're going to look at a ground for review called error of law. That's where the decision maker misunderstands the law that they're applying. In the second video, we'll look at some of the grounds for review that focus on the evidence and whether the evidence is considered properly. In the third video, we're going to look at the grounds for review where the suggestion is that the decision maker has behaved improperly. In the fourth video, we're going to look at a special type of administrative decision called a discretionary decision and the things that can go wrong there. In the final video, we're going to look at the 2 remaining grounds, which are called Wednesbury unreasonableness and uncertainty. So let's get started. Section 5(1)(f) of the ADJR Act says that a person can have an administrative decision reviewed if the decision involved an error of law, whether or not the error appears on the record of the decision. Now, this ground for review is actually a lot more interesting than it looks. You see, before there was an ADJR Act, a range of the grounds for review, such as all of the errors relating to evidence, which we're going to look at in the next video, they were all regarded as errors of law, but they're now listed differently. In its modern sense, errors of law mostly focuses on situations where a decision maker asks themselves the wrong question. Ever since the start of your degree, you've been taught to ask yourself, what is the test and what are the elements? It makes sense that if a decision maker doesn't get those questions right, they might end up making a completely off-kilter decision. Now, the authorities on this question are 2 cases, a High Court case called Craig in South Australia and a British case called Anisminic against the Foreign Compensation Commission. But those cases are actually not super helpful on the point, so I'm going to make up an example. Let's stick with the scenario we've been using for the last few weeks, the idea of a learner driver and their logbook. Now let's imagine that the rules for the logbook included the following. This is made up, it's not in the actual regulation. But let's pretend there was a regulation that said the chief executive can only approve logbooks which were maintained on a smartphone app approved for that purpose unless extraordinary circumstances exist. So what's the test there? Extraordinary circumstances. If you can show extraordinary circumstances, then you might be able to keep another type of logbook. So now let's imagine that our learner driver kept their logbook on paper because their family is in poverty and they're unable to afford a smartphone capable of running the app. So they apply to have their paper logbook recognised. The chief executive or their delegate is supposed to ask, are there extraordinary circumstances? But let's say they just invent a rule that poverty cannot be an extraordinary circumstance. Can you see that by inventing this rule, they've actually changed the test. If they went ahead and made a decision based on the wrong test, then they'd have made an invalid decision. So they'd respond to our learner driver by saying, "We do not approve your logbook because extraordinary circumstances cannot include economic circumstances." Well, the learner driver comes to you as a lawyer, your answer would be, that decision is invalid because it involves an error of law. The error of law is that the decision maker has not applied the proper test, so they've not actually made the decision they were supposed to make. Now, the next thing you might have noticed in the ADJR provision was that it said that a decision is reviewable if it involves an error of law, whether or not the error appears on the record of the decision. What's that all about? Well, under the common law, an error of law could only be appealed if the actual decision document showed the error of law. If the decision document didn't show the error of law, it couldn't be appealed. What does that mean? Well, let's stick with the same made-up example. Let's say the delegate comes back to our learner driver with a decision on paper that says, "We cannot approve your paper logbook because we do not hold the view that extraordinary circumstances exist in your case." Now, can you see if you just read those words, there's no error of law evident from those actual words? Now let's imagine the decision document said, "We do not approve your paper logbook because your circumstances relate to economic poverty, and economic poverty cannot be an extraordinary circumstance." Can you see it's the same decision, but this time the error is clear on the face of the document. See the distinction? Now that I've taught you about the distinction though, you can forget it, because the ADJR Act makes it clear that an error of law can be appealed whether or not it's apparent on the face of the document. If there's an error of law, the decision can be reviewed. They put it in those words just to make it clear that the statutory position is different from the old common law position. So that's the first video of the 5 we're going to work through this week. In this video, we've looked at the idea of an error of law, where the decision maker misunderstands the law. We now know that decisions can be reviewed if they're based on an error of law, regardless of whether the error appears on the face of the decision or not. Next, we're going to look at the grounds of review that focus on evidence. See you in video 2.